Mr Speaker, my question is to the Minister of Labour. Was it the government's intention when it introduced the 90-day employment scheme that the usual requirement to communicate the reasons for dismissal in writing to the employee after they are dismissed does not apply when an employee has been dismissed during their trial period?
The Honourable Kate Wilkinson.
Mr Speaker, firstly, can I thank the member for the endorsement that the 90-day trial is actually an employment scheme. But in answer to the question, yes, there is a very narrow exemption from the requirement under Section 120 to provide a written statement requested within the 60 days and 40-day requirement, but we have made it very clear this does not affect the good faith requirements to be communicative and responsive. In practice, we expect that fair and reasonable employers will tell employees why a job didn't work out.
The Honourable Trevor Mallard.
What about the unfair ones? What about the unfair ones?
Supplementary question. Was it her intention when introducing the 90-day provision that an employer would have no obligation to supply a reason for dismissal to an employee or former employee?
The Honourable Kate Wilkinson.
Mr Speaker, it was our expectation that a fair and reasonable employer will tell employees why a job didn't work out, but the intent of the policy was that the employers did not have to go through the legal rigmarole of providing formal written decisions.
The Honourable Trevor Mallard.
Is she satisfied that the legal change she made met her intention as she expressed in the first part of her last supplementary answer?
The Honourable Kate Wilkinson.
Mr Speaker, I'm satisfied that the law is working very well. We've had it in place since March 2009 and actually the sky hasn't fallen in.
Point of order, the Honourable Trevor Mallard.
Mr Speaker, a relatively simple one, a very careful question about whether a particular supplementary answer, whether the answer as to the Minister's intention had been fulfilled by the law, not whether the law was working generally well. No, she didn't.
Order. Members shouldn't interject while the Speaker is considering a point of order. If I remember correctly, the member asked, is the Minister satisfied that certain things took place? And I understood from the Minister's answer that she said yes to that. She may not have said exactly yes, but her answer indicated that. David Bennett.
Supplementary question to the Minister of Labour. What was the government's intention when introducing the 90-day trial period, and has it been achieved?
Honourable Kate Wilkinson.
Speaker, the government intended to create opportunities for New Zealanders to get into jobs, and the evidence indicates that the trial period is delivering jobs. That is why we are moving to extend the trial period to all workplaces.
The Honourable Trevor Mallard.
Was it her intention when introducing the 90-day provision that a successful claim of unjustified termination would not be able to either secure reinstatement or compensation for loss of employment?
The Honourable Kate Wilkinson.
Mr Speaker, it was the intention in relation to the 90-day trial that a fair and reasonable employer will tell employees why a job didn't work out. It was there to create opportunities for new employees to get their foot in the employment market, and if the employment relationship didn't work out, then it could be terminated.
Point of order, the Honourable Trevor Mallard.
Mr Speaker, again, it was a very careful and very specific question which went to...
to save time to the House, I will invite the member to repeat his question because it was quite a specific question with respect to unjustified claims of unjustified dismissal, so I invite him to repeat it.
Was it her intention when introducing the 90-day provision that a successful claim of unjustified termination would not be able to secure either reinstatement or compensation for loss of employment?
The Honourable Kate Wilkinson.
Mr Speaker, the trial period, it was the intention of the trial period that it only restricts the taking of an unfair dismissal case in the first 90 days.
Point of order, the Honourable Trevor Mallard.
Mr Speaker, the question went to if there was a successful claim of termination, unjustified termination, would not be able to secure either reinstatement or compensation for loss of employment. The question wasn't when the claim was taken, which the member answered. It's a question of whether you could get compensation or reinstatement in the 90 days.
Order, but as I understood the Minister's answer, she, in her answer, implied that an issue of unjustified termination could not arise in the 90 days, that was the intention, was what I understood. If I've misinterpreted the Minister, I invite her to correct my understanding of her answer, but that was my understanding of the answer, which I believe did answer the member's question, because it pointed out that that could not occur during the first 90 days of that trial period. David Bennett, supplementary.
A question to the Minister of Labour. What other reports has the Minister seen on how the 90-day trial period may apply?
The Honourable Kate Wilkinson.
Mr Speaker, I've seen a statement yesterday from the member Phil Twyford that, quote, 6,000 employees could be subjected to the 90-day period at the stroke of a pen, unquote. However, he, as an Auckland member, should know Section 108 of the Local Government Auckland Transitional Provisions Act 2010 makes it clear that all employees who take jobs with the Auckland Council or any related agency are to be considered for the purpose of any statute as having continuous employment. Those employees would not be allowed to enter. Those employees would not be able to enter into a trial period. And can I suggest he might have more luck getting an electorate if he actually read the legislation he was protesting against?
Question number 7, Alan Peachy.
Thank you.